Hello and welcome to Lecture 1 for Topic 10. And in this lecture, we're going to be taking a look at pretrial procedures. There are many things that happen in a criminal courtroom. And so your textbook sort of talks about stage 1 and stage 2 of the main things that happen in the criminal courtroom. Stage 1 are the pretrial procedures, and stage 2 are the trial procedures. And lecture 2 focuses on the rights during a criminal trial. In this lecture, we're going to be talking about stage 1, with a special focus on grand jury and preliminary hearings and plea agreements. So usually when we think about what goes on in the courtroom and criminal procedures, our mind instantly goes to trial. Criminal trials often receive the most media attention. However, as we know, very few cases go to trial. In fact, only 10% of cases actually end up in a criminal trial. The vast majority of court activity is dedicated to pretrial activities. Since so few cases go to trial, it's really critical that we understand the importance of the pretrial procedures. Even though they're not as sexy as a criminal trial, the vast majority of what goes on in the courtroom are dedicated to pretrial activities. And when you do your court report, you're going to see that, the chances of you sitting in on an actual trial are very slim. What you're going to be seeing more likely are initial hearings, bail hearings. You might be seeing sentencing hearings. You might see a preliminary hearing. Those are all of the kinds of things that happen in a pretrial procedure. And so that while it may not be as flashy to learn about, it's incredibly important to learn about it. In the chapter that you're reading this week, there's just a ton of information. There's a ton of information about the pretrial procedures. There's a lot of information about the trial procedures. So it's kind of difficult to boil this all down into a lecture. So we're just going to be focusing on specific areas of the pretrial agreement, the pretrial procedures. But I did want to make sure that we had an overview of what happens in pretrial procedures. So pretrial procedures start after the arrest, because after the arrest, you are basically, taken down to the police headquarters, and you are basically told what your rights are. You're detained, and that you're detained until a decision is made. You're sort of booked. You might be fingerprinted. You might be photographed, and then you're detained until a decision is made to issue whether or not a complaint is going to be filed. That is there going to be a criminal complaint, which is basically a written statement of the charges that you may face. So it's a formal document identifying the charges that you may face. Now, there's always going to be a check on those charges, right? So that's the role that the grand jury or the preliminary hearing plays. And so that a complaint may be issued, but that it doesn't necessarily mean that you're going to actually be charged with a crime. We have to make sure that there's probable cause to sustain those charges, and that takes place in the grand jury preliminary hearing. We're going to talk about the difference between those two things, between the indictment process, which is the grand jury process, or the information process, which is the preliminary hearing process. The arraignment, as you know, is when an individual is brought into a court after the preliminary hearing or grand jury. At that point, they are told what the formal charges against them are. They are asked about whether they understand those charges. They enter a plea of either guilty, not guilty, or no contest. And then at that point, a decision will be made about, if you enter a no guilty plea, a decision will be made about whether or not you will be released on your own recognizance, or whether or not you have to pay some sort of bail in order to make sure that you come back for future court hearings. That all takes place at the arraignment. So you're informed of the charges, that you enter a plea, and bail will be set. And if you plead not guilty, at that point you prepare for trial. But as we know, most cases don't go to trial. So even though you might initially enter a no guilty plea, you may be willing to enter into a plea bargaining, which we're going to talk about. Now, there's a lot of information in the textbook about bail, and bail is an incredibly important aspect of our criminal justice system in the United States. That on the one hand, the criminal justice system has an obligation to make sure that people who pose a danger to community are not out in the community while they're waiting trial, because that can be really dangerous. Also, if there's a flight risk, that if this individual is likely just to take off, right, our government has an obligation to make sure that the community isn't threatened by somebody being out, not under court supervision as they're preparing for trial. And also we want to make sure that justice is served, that this person is held accountable or responsible for their actions. And so if they're flight risk, we have to be concerned about that. And that's sort of the point of bail. The point of bail is to say that if we think you are really dangerous, we may deny you bail. If it's a serious offense, we want to make sure you return. We're going to make bail pretty high. But for a lot of people, even if the bail is set relatively low, if they're poor, they're indigent, they're not going to be able to make any kind of bail. So so basically we have what are known as pretrial detainees that are basically in jail awaiting trial, even though that they may be charged with the crime, but that there's no decision being made yet, and they just sort of languish there. So while I don't want to spend a lot of time talking about bail, on the next slide I do want to show you the percentage of pretrial detainees that make up the overall incarceration rate in the United States, because it is quite significant. So your textbook talks about the number of pretrial detainees. That is, people who are not able to make bail, and so they are sitting in jails waiting trial. And it's a significant number of people. In the textbook, they make it sound like more people are incarcerated waiting for trial than are actually serving sentences. I think they sort of misstated that in the textbook. I think they meant in jails, more people are waiting for trial than are serving out sentences. And that is, in fact, true. When you take a look at this part of the pie, okay, this is all the people who are locked up in the United States in 2020. This shows the pie piece, this orange piece, from local jails. And this quadrant right here, nearly, I think it's 470,000 people are pretrial detainees, that they have not been convicted and they're waiting for trial. While this quadrant here, about 150,000 are actually serving terms, their sentence, serving out their sentence in jails. Now, jails are, for people, they go there if they're sentenced to less than a year. And so while it is true that people in jails, they have more trial detainees, that's not true in the state prison system. Okay, so you're not going to find in state prison pretrial detainees. They're going to be in jails. And so, but still, nearly 500,000 people are incarcerated waiting trial. And so make sure you read about that and efforts to reform bail and what's successful and what's not successful. Because when you think about due process and fairness and justice, having that many people who, just because oftentimes they can't make bail because of their income level, that has some pretty significant implications on not just on justice, but it's really costly to the taxpayer as well. It costs a lot of money to keep people behind bars. I think your textbook said $200 a day to keep people in jail. And so it's quite costly to the taxpayer as well. Okay, so let's look at the one focus on the pretrial procedures, which is charging the defendant. Now, as we know, the charge is selected by the prosecutor, but there's a check on the power of the prosecutor. So that's kind of making sure that the process is fair, or at least fairer than it would otherwise be. The goal of the charging process is to figure out, is there enough evidence? In other words, is there probable cause to charge a person with a crime? It's a lower burden of proof that the state needs to demonstrate. They basically have to say that it is reasonable to believe, based on the evidence, that this person did commit this crime. But that's the burden of proof that the state needs to prove in order to charge somebody with a crime. Now, your textbook talks about that there are two types of charging processes. The indictment process, which is we use a grand jury to check the prosecutor to see whether or not charges are warranted. And then there's what's known as the information process, which is the preliminary hearing process. Keep in mind that you only have a right to a grand jury if you are charged with a federal crime. The grand jury provision of the Fifth Amendment has not been incorporated to the states. So a lot of states don't use the grand jury. They use the preliminary hearing. The Supreme Court deemed that grand jury was not a fundamental liberty that was necessary to due process. And so that's the way it is. So in Wisconsin, the preliminary hearing is used quite frequently. So let's look at the difference between the two. Okay, so let's talk about the indictment process and a grand jury. A grand jury is actually a jury of people, okay? That there are different kinds of juries. One is a grand jury and one is a petite jury. And the petite jury is the jury that is called to actually sit in and render a verdict of guilt or not guilt in a jury trial, okay? That's not what a grand jury does. That a grand jury plays a different role. It provides sort of a check on an investigation that a prosecutor is engaging in, and also provides a check on whether or not an individual should be charged with a crime, indicted. But like a jury, like a trial jury, like a petite jury, it is made up. It's called a grand jury because it's bigger than a petite jury. It's made up of between 16 and 23 randomly selected adults. And so there's a veneer process, there's a voir dire process, and a grand jury will sit like for maybe, a month or so. I mean, and not they're there every day, but it's like if the prosecutor needs the grand jury, they will call upon this randomly selected group of people. The grand jury has two major roles. One role is that it serves as an independent investigating body. Now, the grand jury itself doesn't do the investigation, but the prosecutor's office will engage in an investigation. And so the prosecutor will draw up an investigation, and then they are generally investigating the presence of some sort of criminal activity in its jurisdiction, like in its county or in its region, right, in its district. They're basically, it's not going to be investigating one person, but it will be investigating criminal conduct. So it might be investigating child pornography or sex trafficking or organized crime. And so then the prosecutor will present this information to a grand jury through its investigating, and then the grand jury will look at it, and then it will issue what's known as a presentment. And what that is that it's basically saying that the presentment is saying that after looking at the evidence of the criminal conduct that's going on, we think that charging should be considered. And so another thing that the grand jury does is it determines whether or not that a person should actually be indicted for a crime. So it determines whether the state's accusation of criminal conduct justifies a trial. And that's what the indictment process is. An indictment is a written accusation of charges. It's written by the prosecutor. It's submitted to the grand jury. And then the grand jury looks at and considers the evidence, any testimony, a presentation of evidence that takes place in the grand jury. And then the grand jury will issue either a true bill or a no bill. A true bill is basically saying thumbs up. We agree that this we endorse the indictment. We think this person should be charged with this crime. A no bill is where the grand jury would say, nope, we don't think this person should be charged with a crime. So in theory, a grand jury is supposed to be like this check on the power of the prosecutor. It doesn't always work that way in reality. So the grand jury is sort of the prosecutor's show. It meets at the request of prosecutors. There's no judge that's present. A defendant isn't, and the defendant's attorneys are not present. This is the prosecutor presenting information and evidence to a grand jury. It's also a closed or secret proceeding. So there's no public account of what takes place in a grand jury. It's a closed process. So what's the purpose of the grand jury beyond seeking an indictment? Why would a prosecutor want to do a grand jury? Well, it allows the prosecutor to question witnesses and secretly And so it gives them sort of an opportunity that the witnesses might feel free to speak up. It doesn't harm their reputation, because it's, nobody knows that you've been called before the grand jury. That might include the potential defendant, the potential criminally accused. So it's not going to harm their reputation. You're free to speak. Nobody knows that you are being questioned in the grand jury. The prosecutor can sort of see it as a trial run before a trial, so gets information that they wouldn't otherwise get because they're able to call the witnesses in front of the grand jury. And that it can be used in preparation for trial. So you're already collecting evidence to use in trial. So those are some of the reasons why a grand jury might be called, because it allows the prosecutor to begin an investigation that they can then utilize if in fact the case goes to trial. So the purpose of a preliminary hearing is the same as the grand jury. It's just a different process. That rather than it being sort of the prosecutor's show, it's not done behind closed doors, right? It's a preliminary hearing is conducted before a judge. It's open to the public. Everybody is present. So in the grand jury, the defendant isn't necessarily present. The defendant's attorney isn't necessarily present. That it's only the prosecutor and the grand jury. In a preliminary hearing, the prosecuting attorney is there, the defendant is there, and the defense attorney is there. And evidence is presented by the prosecutor, but the defense attorney has an opportunity to question the evidence that's being presented. So the whole goal is that, like, trying to prove that this person should be charged with the crime. Well, that's easier to do maybe in a grand jury, because that there's no questioning of the evidence that the prosecutor is presenting. But that's, it's a little bit more adversarial in a preliminary hearing because the defense attorney can call into question the probable cause of that there is no probable cause to sustain these charges. The downside of it is it's kind of public, right? So like when you are at a preliminary hearing and the charges against you are being considered, it's a public endeavor, so people know that you are potentially going to be charged with a crime, even if you end up not being charged with the crime. The judge decides, so a grand jury doesn't decide whether or not a person should be charged, right? A grand jury, a body of people, citizens, issue an indictment, a true bill of indictment. In this case, the judge decides that whether the charges should be dismissed, or if there is probable cause, that then the individual should be charged and potentially bound over for trial. It's called the information process because the information is the formal charging document. So like in a indictment process, the formal charging document is the indictment. In a preliminary hearing, the formal charging document is known as an information. So to conclude this part on the preliminary hearing or the grand jury, so what are the benefits of the grand jury? What are the potential drawbacks? What are the benefits of the preliminary hearing? What are the drawbacks? And if you were, facing charges, which would you prefer? Would you rather it be you facing an indictment? Would you rather that take place via the indictment process, where it's private, that nobody knows that that the prosecutor is actually considering charges, but then you don't really have as a defendant, you don't really have a right to question those charges either. You don't get to tell your side of the story. Or would you prefer the preliminary hearing? And also, which system do you think is fairer? Do you think the preliminary system is fairer, comes closer to due process of law, or do you think that the grand jury system is fairer? And maybe it depends on the kind of crime. So just some things to think about. Okay, so once you are charged, you must be told of those charges, and that takes place at the arraignment. And the arraignment is when the judge, that there are charges that are going to be filed. The judge informs the defendant of the charges. They make sure that the defendant understands what they're being charged with. That, as we know, or as you will know in the next lecture, but reading in your textbook, that the Sixth Amendment says you must be competent to stand trial and understand your charges, so that can be evaluated at the arraignment as well. And then you're asked to enter a plea, guilty, not guilty, no contest. And so you can read about the differences, like why somebody would plead no contest versus guilty in the textbook. Counsel will be assigned at this point because you're being, because if you particularly, well, whether you plead guilty or not guilty, you need counsel. And then if you do plead no guilty, then bail can be set or redetermined at this point as well. A bail can be set sort of earlier as you are at one of your initial hearings, but bail set if there's no guilty plea, or if there's, that you plead not guilty. And so just keep that in mind that takes place at the arraignment phase as well. So plea bargaining, let's talk a little bit about plea bargaining. And I know they talk a lot about that in Locked In. So a lot of this might just be refresher from what you just read in your textbook. As we know, 90% of cases do not go to trial. Most cases result in a plea agreement. And the plea agreement, as you know, is this ongoing negotiation between a prosecutor and the defense attorney. And the defense attorney obviously representing the client themselves, the person who is charged with the crime. Now, in your textbook, they talk about how judges are not supposed to participate in plea deals, right? This is really supposed to be a negotiation between the prosecutor and the defense, and the defense attorney's client. The reason the judge isn't supposed to participate is because the judge isn't supposed to be a part of the bargain, right? They're not supposed to participate in some sort of deal. They are supposed to act as an impartial participant in the court, right? Not sort of saying, oh, well, if you drop the charges, then we'll plead guilty, and well, no, how about, striking some sort of deal. If a judge is involved in that, then the message that's sent to the criminally accused is that the system is sort of rigged against them because the judge has sort of is encouraging the person to accept a plea agreement. And so there's, judges aren't supposed to be involved in this process. Well, your textbook identifies four sort of reasons for why the prosecution and the defense engages in plea bargaining. The major one is that charges may be reduced to those of a lesser offense. So as you learned in Locked In, a lot of times prosecutors will really charge somebody with a really either a lot of charges or very serious charges, and they use it as sort of a negotiating a tactic in order to say, okay, look, we charged you with first-degree intentional homicide, but we're willing to go down if you're willing to not take this to trial. So that can be one of the motivators for the plea bargain. The prosecutor may reduce the number of charges, right? And so, as we just saw, since with the Derek Chauvin, the jury deliberations have been released, and Derek Chauvin has been found guilty of all three of the charges, right? He didn't engage in a plea bargain, obviously. And he was convicted of all three of those charges, and he's going to face a significant sentence. And so part of the negotiating tool with the prosecutor may be to reduce the number of charges, right? Say, well, we'll only charge you with one charge rather than the three that we initially said we would. That the prosecutor may promise to recommend a lenient sentence, such as probation, and that's something that the defense attorney will work for these things too. I mean, the defense attorney is trying to represent their client and say that, okay, look, we'll plead guilty, but we want a very short sentence, or we want the sentence to be probation. And so the defense attorney also is trying to look out for their client. And also the negotiations might revolve around the charging somebody with a less negative label. So rather than charging somebody with and not just a negative label, but something that can actually have huge consequences on a person's life, rather than charging somebody with sexual assault, you might charge somebody with aggravated assault. And then that would mean that they wouldn't have to register on sex offender registries. Okay. And so those are some of the, main points that your textbook raises up regarding sort of negotiating tactics and reasons during plea bargaining. Well, there are pros and cons of plea bargaining, and we just have to do a cost-benefit analysis of whether we think the pros outweigh the cons, or whether the cons are much weightier than the benefits. So the pros are, that our court systems are already overworked, and so that by people pleading guilty, particularly if they are guilty, it reduces the overall cost of the system. It can be administratively efficient because you don't need to go through a trial, and that if people plead guilty, then more time and resources can be spent on more serious cases. So it could be a good way of disposing of a case in a less costly and a less labor-intensive manner. But there are significant cons to plea bargaining as well, which they talk about in Locked In. That one of the cons is that your textbook talks about that people will plead guilty because they don't trust the system. They plead guilty because they've been detained for so long. They just in pretrial detention that they just want to get out of it. That they will plead guilty because they really are really fearful that if they went to trial, they would be convicted of these charges, even though they may not necessarily be guilty of those charges. Okay. And so it raises the danger that an innocent person will plead guilty because they are poor or a minority. Now, there's been some reforms around that where there's more emphasis placed on the judge to make sure that the evidence the evidence of the crime actually indicates fairly strongly that this person is guilty. There's kind of a move away from accepting guilty pleas from people that really probably aren't guilty, right? So there are some reforms in that area. It also, when you plead guilty, you basically you waive your constitutional rights to a trial. You also waive your constitutional rights to an appeal, and so you're giving up a lot of your constitutional rights when you plead guilty. There are legal issues to keep in mind with plea bargains, and this is where we'll end. That plea bargaining, you have to demonstrate that an individual got effective counsel. So even if you do plead guilty, that doesn't mean that you couldn't challenge that plea because you said you didn't have effective counsel. You have to have effective counsel, and you also your plea has to be voluntary. It cannot be coerced. You can't be pressured to plea. And that promises need to be upheld. So if the prosecutor says that in exchange for a guilty plea, we're going to drop a charge or we will recommend a lenient sentence, then the prosecutor must keep that promise, but the accused must keep that promise as well. That if the charges are lowered, then the accused must follow through on their end of the bargain and actually plead guilty. And as I mentioned before, the judge should not be involved in the process beyond the approval or denial of the bargain. But the judge can deny the plea agreement, okay? So the judge does play that role as sort of an umpire. Okay, that's it for this lecture. Thanks for listening, and I'll talk to you again soon.